Okay, so I'm going to speak about legal protection by design for AI systems. And as you can see, there is light at the end of the tunnel. I'm first going to shamelessly advertise a book I published last year. I think it's in open access, available with Oxford University Press. This is the result of teaching 8 years master's student of computer science about the law. And it's actually the only dedicated textbook at a global level that introduces law to computer scientists and other relevant audiences, engineering, etc. So it has a focus in the mid part on cybercrime, intellectual property, data protection, private law, liability, legal personhood, which are dedicated domains of the law, very important for computer scientists or other people working with computing systems. But it also tries to explain how the law actually operates, so its inner operations, and demonstrating how the specifics of legal reasoning work, because of course they work different and similar to the way computer code reasons. And there's a structure, etc. Some other things that I want to highlight that may be relevant in relation to what I'm going to speak about. Maybe if you are interested in these things, note them down. So this is an article about the issue of bias, where the main point I'm making is that machine learning is inherently looking for bias. So there is a training data set, you're looking for patterns, you're looking for the relevant distribution in that data. So compared to a random distribution, you are actually looking for a bias, and that bias is going to be productive of the output of your system. So instead of always talking about wrongful or unlawful bias, let's first talk about that productive bias. I will return to this, and recently I published the issue of proxies, which moves into a recommender system, but the issue of proxies is something that is relevant for all machine learning operations and even for more code-driven systems. And I will also briefly go back to that. What I want to do today is 5 things I will spend quite some time thinking about, discussing with you what I call the new everywhere. So this environment that we are in now, that's been sort of reinvented by computing systems, let's put it that way. After doing that, I will move into the legal framework in the European Union. I will discuss what actually is meant with the notion of legal protection by design. I will compare that to the relationship between law and ethics, because we have, of course, many ideas of ethics by design, AI and ethics, etc. And then end with briefly saying something about the idea that we do not want innovation per se, we want good innovation. And that would be, as far as I'm concerned, innovation towards AI systems that are resilient, robust, reliable, and responsible. So let's look at all these new everywheres. So I want to take a step back and wonder in what sort of environment, how we have rebuilt, reconfigured, reconstituted the environment we are in. This is basically hinging on 2 things. That is the internet, this system of packet switching, routing, and the protocols that enable it. And this is, in first and last instance, about hyperconnectivity. It's about speed, automation, network effects, asynchronicity. If I send you an email, you can decide when to open it, but it's already in your inbox. That enables new ways of coordinating things. There is borderless communication, though I would put that between brackets. There are, of course, many new borders coming up, though not necessarily territorial. And these new borders are often implemented by those who profit from them. But the main thing of the internet is the hyperconnectivity. Underlying this new environment is, of course, computing systems And I'm now loosely defining them as systems that are capable of manipulating data based on coded instructions, based on many different programming languages. What is interesting is the many different types of programming languages and the computational complexity that we have developed. As an example, which is very relevant here for what is often called AI, but let's face it, most people who talk about AI are now talking about machine learning. So things like a computing language like Python, which is multi-paradigm, which means it combines different types of programming languages. An example of that is TensorFlow, basically an off-the-shelf thing that you can use to build things, even if you don't really understand how it all works. I want to again take a step back. It happened that this morning I saw an article by Rodney Brooks, the famous, one of the computer scientists that worked in robotics at MIT and basically developed and invented the most used robot in the world, that is the vacuum cleaner, Roomba. So he wrote an article on Claude Shannon yesterday. And one of the points he makes is that Shannon moved from the electrical part of computers that didn't yet exist to another abstraction level, showing that Boolean algebra could be used to move away from the relays themselves, so the electrical level, into a more abstract understanding of the function of a circuit. Then we're talking electrical engineering and maybe beginnings of computer science. He used this algebra of logic to analyze and then synthesize switching circuits and to prove that the overall circuit worked as desired. And in his thesis, he invented the and or not logic gates. And they're basically the building blocks or foundations of computing systems. At some point, he also suggested, when he was thinking about chess, about computer systems playing chess, that it might be possible to improve his program by analyzing the games that are already played. So we're now talking about historical data, memory, training data, basically, we would now say, and adjusting the terms and coefficients in its heuristic evaluations of the strength of board positions. This is basically machine learning. He didn't use the term, but soon after that, 1959, already quite a long time ago, Samuel published a paper about Shannon's work, and he actually uses the first time the term machine learning in the title. So Brooks is saying, look back at Shannon and the foundational work that basically defines computing science, computing systems in the environment that we're now living in. We're talking about hardware, software, connectivity, but what seems very important is to understand that this is all enabled by these different levels of abstraction. And what these systems actually do, you can try to categorize it, and I'm going to do that here, but all these categorizations are overlapping, and that's also key to this hyperconnectivity of computing systems. So think of cloud storage, using AI for cloud storage, optimization, server platforms. Think of using AI for smart grid management, load balancing, demand response management, which basically can no longer be done when you use, when people are allowed to upload energy to the net without predicting energy usage. Recommender systems, need I say more? Search, and of course you could say that search is an example of a recommender system because it gives you recommendations on what to look at first, basically ranking. And this is not only about the web, but it's also about legal search, very important, and search in medical diagnosis, etc. We have NLP, natural language processing, both understanding in the sense of mapping stuff, document classification, or in the sense of generating text. Robotics, and we can talk about exoskeletons, spot, vacuum cleaners, connected cars, autonomous weapons. And then we can talk about the Internet of Things, about sensor technologies, remote healthcare, about smart cities, and more generally about what has been called intuitive computing. And it is basically a move towards ubiquitous cyber-physical infrastructures that basically give us a choice architecture. So it determines what we can actually look at because we have an abundance of information. So we're all the time looking for the right filters. And we are used to that now online, but this is moving to our offline environment also, which is basically becoming an online environment. Again, taking a step back, when we talk about AI, at this moment, let's say in the popular press, people are talking about what has been called machine learning. And I'm going to look at Tom Mitchell's definition of machine learning to remind ourselves what we actually mean when we say that machines learn. So basically he said machines learn from experience E with respect to some class of tasks T, in performance measure P, if their performance at tasks in T, as measured by P, improves with experience E. I always say when I use this slide, this is like poetry. And it's also like math because it doesn't have any extra information. It's very compressed, and it is precisely what machine learning is about. And you can see there are so many limitations and constraints necessary to make things work. So how is this done? First of all, we must remember that experience E consists of data. It does not consist of, for instance, sounds. No, it consists of the data that has been picked up by a sensor that is trying to trace sound. So data represent, or it is a trace of, for instance, sound, image, temperature, or text. And at a slightly higher level of abstraction, data is about objects, states, changes of states, and relations between objects. Now, what machine learning basically does is it seeks to uncover patterns in the distribution of the training data. And we must remember that the more data you have, the more patterns you're going to find, and that many of these patterns may be spurious. If you detect a correlation in a data set between the length of feet of the persons and their general knowledge, and the data set consists of people between the age of 0 and 18, then it should be clear that there is no causal relationship between the size of your feet and your general knowledge. This is a spurious relation. It's caused by the fact that while you grow older, you pick up more general knowledge. And here it is kind of obvious, but many of these data sets, unstructured data, etc., that's not obvious at all. And one of the most important tasks we now have is to figure out when the patterns are spurious. So think of deep learning systems, which are opaque, as we all know, difficult to interpret. It may be that we are working on spurious patterns that are valid for a long time because the confounding factors that are impacting the output are around for a long time. So you don't notice that the pattern is spurious. But when the confounding factor disappears, your system won't work. So this is extremely important. Basically, the patterns that machine learning looks for in the distribution of data is a mathematical function. So your hypothesis space, as it's called, consists of mathematical functions. Now, so what? Why should we be interested in this? Well, because machine learning is based on the assumption that the distribution of future data, that's what you want to know. You want to try and figure out how we can anticipate the future. The distribution of future data is similar to the distribution of the training data. And as any computing scientist knows, that assumption is necessary to make the system work. If you don't assume that, it makes no sense to build the system. But we also all know that it's not necessarily true. Now, why should we even care about all this? Why don't we just take TensorFlow and build some nice stuff? And if it works, it works. Well, because this raises issues of bias. As I said, bias at the most deep level in a computing system, machine learning system, is the distance between a random distribution and the distribution that you have. And that bias can be constructed based on machine learning algorithms, based on the hypothesis space, based on the math that you use in many different ways. And you're trying to find the bias, the pattern that is productive. That's very interesting, but the problem is that the bias you have found, the pattern you have found, may be incorrect. On top of that, correct or incorrect depend on your purpose. In the same data set, you can find different patterns depending on the purpose. And next to such a bias, perhaps being simply incorrect, it might also be wrongful because it might pick up on disabled people, on racial characteristics, or other things that are not even prohibited. Like it might pick on people with a low earning capacity and exclude them from some certain opportunities, which some people might say is wrongful. Then we're talking ethics. It might also be unlawful if they pick on a prohibited ground, as I said, like race or being disabled, sexual orientation, etc. So all these issues are raised, and we all know there is a vast literature now about bias in artificial intelligence. But there is another issue, which may be even more important, and that's the issue of proxies. So a computer only understands at its bottom level Boolean algebra. So you'll have to translate any real life objective that you have in terms that a computer can understand. And that means you have to pick on proxies. So if you want to sort of predict whether a person is going to recidivize, is going to commit another criminal offense, and you want to build a system that based on the history of other people in the same situation, then you're going to have to find some sort of proxy for whether in that history people committed criminal offenses or not. That proxy will probably be the register of the police or of the criminal justice authorities. We all know that that's not the same as who actually committed crimes. So this is just one example, but in fact, if you think, for instance, of supervised machine learning, all the feature and target variables that you develop, and the feature variables that you develop via labeling, they are proxies. And the problem of the system is it only can understand the proxies, can only see the proxies. It's blind for anything that's outside that. So if you don't pick your proxies well, and especially if you're not aware of the limitation of the proxy, you might get a lot of things wrong. And all this, in turn, of course, generates risks to safety, health, and fundamental rights. Now, let's go a bit deeper into the problem. If you don't really understand the why of the patterns in your training data, the assumption that the same distribution is valid for future data, that's the assumption I talked about a few slides ago, an assumption you need, then that assumption may actually become generative. There's a famous sociologist that said if men define a situation as true, it's true in its consequences. This was Robert Merton referring to the Thomas theorem. And for a long time, I've said that we see this now again, in the sense that if machines define a situation as true, it will be true in its consequences to the extent that people take that machine definition as a reality. That means you may produce what you predict. And this is a well-known effect, which was, for instance, described by econometrist Goodhart and re-articulated by Marion Strathern. She said, if you use a measure as a target, and it's no longer a good measure, and this is a problem, of course. So if you tell scientists, if you want to know the quality of scientific output, and then you begin to measure it by looking at how many things people publish in renowned journals, then you're measuring. If you're then going to use that as a target, so you're telling scientists, we want you to publish at least 3 articles per year in journals with a certain impact factor, then the behavior of the scientists will change. They will perhaps start writing more, they will perhaps start writing in different types of journals. Also, the behavior of the policymakers or the supervisors may change. And that means that what you were measuring earlier no longer works. We all know what the result of that is in academia, an explosion of journals. Everybody is spending their time on reviewing articles. And in the end, when you try to detect quality, that is done based on data, not on looking at the actual content. And that sort of incentivizes repetition. So this is also like saying that the best way to predict the future is to actually create it. This is something that has been attributed to Gaber, Lincoln, I think, and many others. And there is a wonderful work by Elena Esposito called The Future of Futures, also about predictions, in this case, predictions within the financial markets. And I'm sure you're aware that within the financial markets, it's the quants, so people who studied, for instance, theoretical physics, and then computer science, and then develop AI systems to predict things in the stock market. So her book was published in 2008, written just before the financial crisis. And it basically, in many ways, explains where that financial crisis came from. So I always summarize her book as saying, we have many present futures. Present futures is the future that we imagine now. The future, in a way, only exists as a present future, because once it's become the future, it's the present, right? So we have many different present futures, and that's good, because we can discuss with each other, we can calculate, we can try to foresee how we can best anticipate these futures that we envisage and maybe try to make come true. But we should always remember that we have only one future present. And we have to be very careful with that, because we are all vulnerable. And I'm going back to Brooks' article on Shannon, where in the end, last paragraph, he recaps, he says, well, what Shannon basically invented is information theory, logic gates, non-numerical computer programming, data structures, and arguably even the foundations for machine learning. And then Brooks wonderfully says, Claude Shannon didn't bother predicting the future, he just went ahead and invented it. So another way of saying this is that we, and especially those who are developing AI system or machine learning systems, is the online environment to what's called an on-life environment. That means you're moving towards IoT decision-making, so Internet of Things, this ubiquitous realm of smart homes, smart cities, with sensor technology, etc., where these appliances and the system they are continuously talking with in the computational sense are going to make a lot of decisions for us, because otherwise we're going to be totally distracted if we have to provide our consent all the time or think about it, right? So also in our real life environment, we're going to have choice architectures determined by these systems. And in the end, by the developers who decide what sort of constraints these systems have and what sort of actions they enable. And of course, we're also moving towards metaverses. That's another realm of discussion. I'm not going into that today. So let's look at the legal framework within the EU that applies to AI. Well, that's enormous. So I'm going to focus. I'm going to focus on data protection. You probably all know about the GDPR, on the underlying Charter of Fundamental Rights of the European Union, which connects to a much older convention in Europe, European Convention of Human Rights. And then I will look briefly into the proposed AI Act and other parts of the EU digital strategy. So 2 days from now, on Friday, it's Data Protection Day. And you see, we're talking here about the Council of Europe. The Council of Europe is the institution. It brings together 47 European states, amongst which Russia and Turkey, for instance. It's a very large international organization. It should not be confused with the EU that has 27 member states and it's much more integrated. They issued a convention, Convention 108, on data protection much longer before the EU developed legislation here. And this is celebrated every year. Let's look at the GDPR. So many people think that the GDPR is about privacy. And I'm going to tell you immediately, it is not. It is also about privacy, but it is not about privacy. The word privacy doesn't occur in the GDPR. In a footnote, but that footnote is a reference to the privacy directive. And that's why if you put search on, you will find one privacy. Basically, the GDPR provides a set of conditions or requirements for what it calls fair, transparent, and lawful processing of personal data. Those conditions, first of all, consist of a set of principles. Principles not in the sense of ethical niceties. These principles are basically rules that people, entities that process personal data have to comply with. And to summarize them, it's basically about purpose limitation. No, you cannot just collect whatever data, whatever low-hanging fruit you can find. You have to think about whether it is necessary for the purpose that you are targeting. Basically, you're free to choose the purpose, but after specifying that you have to process the personal data that you really need for that and not whatever you might like. Of course, that's related with data minimization. And one of the important principles is also accountability. So whoever determines that purpose and means is accountable to comply with the GDPR. Next to these principles, the GDPR has another set of conditions, or actually it's one condition that says you need a legal basis when you're processing personal data. But that legal basis is not consent. Many people think that the GDPR is about consent, notice and consent, about total control over your data. That is absolutely not the case. There are 6 alternative legal bases. Consent is just one of them, and it's not a very good basis. Why? Because people are allowed, according to the GDPR, to withdraw their consent at any moment, because consent has to be given freely. That's why you can always withdraw it. And it also says now in Article 7 that withdrawing of consent must be as easy as providing it. So you can't give people a very easy way to consent and then hide the withdrawal of that consent deep in your website. And steep fines have been imposed now for companies that violate that requirement. So there are many other, 5 other grounds. So contract, sometimes it's necessary to process personal data because of a contract. A legal obligation, which is basically whenever the government does something, they will need a legal obligation. Vital interests of the data subject or others, a public task of or a task executed by a public authority, and the legitimate interest of the data controller. So there are 6 grounds that's very important. They give a lot of flexibility, and they're sort of tuned to what you need to process personal data. What is important is to understand that respect for individual persons requires that you can't just go around and collect their data and do whatever you want with it. That's the ground. The second ground is that the GDPR basically has as an objective the free flow of personal data between the member states. So the EU is an economic organization in the first instance, historically. So it's very focused on harmonizing obstructions within the market. So the GDPR puts a threshold on what you can do when you process personal data, and it aims to harmonize that amongst the member states. Okay, so there are also a set of dedicated transparency requirements. There is a risk approach. So both the required data protection impact assessment, which is required if the data processing that you want to commence, to start with, has a high risk for fundamental rights and freedoms. And note that it doesn't say a high risk for privacy. It says a high risk for fundamental rights and freedoms. So also in the objectives of the GDPR in Article 1, you can see that it's targeting the protection of fundamental rights, not just privacy. So the idea is that if you consider using artificial intelligence, new ways of or developing a new business model, or doing research and using new technologies, that you have to, before you implement that, foresee what sort of infringements of the fundamental rights may occur. And then there is a duty, if that's highly likely, to mitigate that and to use both technical and organizational measures to do that. Then that brings us to data protection by design. Here, the idea is again that you foresee potential infringements of fundamental rights and freedoms. And from the very beginning of developing your architecture, your system, do it in such a way that that sort of threats, that sort of potential infringements are minimized. Okay, so that's a very important aspect of the GDPR. Then, of course, there is accountability. This is not a set of ethical principles. Why not? Well, that would make everything dependable on ethical inclinations. And that might mean that a company that intends to stick to these principles is pushed out of the market by others who have no such scruples, right? So the idea is to create a level playing field by fines, we all know, very high fines, and private law liability. There are now a lot of cases all over Europe, usually class actions. And we now also see big damages that have to be paid when the GDPR is infringed. Of course, the enforcement of the GDPR takes years. Why? That's because we don't live in a dictatorship. We live in a democracy. We live under the rule of law. So if companies or governments violate the GDPR, this has to be investigated. And this has to be decided by a court of law. And that takes time. And that's good, as long as in the end it is clear what is allowed and what is not allowed. Last thing about the GDPR is the so-called Brussels effect. any company that wishes to compete on the internal market of the EU, if the EU has the most stringent and detailed rules on data protection, then those companies will tend to adapt to the GDPR, to the EU legislation, because then they can assume that they will be compliant everywhere else. And transnational companies have more to do than to develop dedicated subsystems in their business processing, depending on jurisdiction. So interesting books have been written about the Brussels effect, basically bringing it down to this. So whoever wants to compete on this market will pick this more stringent legislation that is nevertheless very reasonable, because it can then assume that it's compliant everywhere else. The GDPR, taking a step back again, the GDPR is targeting the protection of fundamental rights and freedoms whenever the processing of personal data may infringe those rights. I'm just picking out from the Charter a couple of fundamental rights and freedoms that are important when you are developing these systems. Obviously, the fundamental right to privacy, the fundamental right to data protection, but also freedom of thought, conscience, and religion. What if, by way of emotion recognition technologies, or let's say analysis of text or user behavior, a system, or even by MRI scanning, a system would be capable of, or let's keep our feet on the ground. If a system would claim to be able to estimate what you're actually thinking and think of political opinion, for instance, how does that relate to freedom of thought? When would that be infringed? Think of neuromarketing, etc. Freedom of expression and information, well, that's clearly at stake all over the place, because we're now trying to impose moderation duties on big tech, but how does that relate to freedom of information? You could take a step back and say, how does actually the ranking that a search engine does relate to freedom of information? One thing is sure, if the search engine would just give us everything that's on the web without ranking it, we would not understand anything. We would just throw it out. So we need ranking, but that ranking supplies us on the top side with some things and not with other things. And the idea that that's all neutral and just a matter of technical excellence, I think we know that that's not the case. There is a freedom to conduct a business. Sometimes that's in tension with data protection, with privacy, with freedom of thought, etc. But it's a fundamental right. It refers to the freedom to contract and property rights. Prohibition of discrimination, very important because of the unlawful biases that may occur in the output of these systems. And good to mention that the Charter of Fundamental Rights of the EU is aligned with the European Convention of Human Rights, which exists for a much longer time. So in as far as the fundamental rights overlap with the human rights in the convention, the court that decides on infringements of fundamental rights will look at the case law of the other court. Okay, let's now basically move towards the end by a very brief discussion of the proposed AI Act. The AI Act is a very big act. It's a complex animal, and it's also a moving target, because we now have the Commission's proposal and the latest draft of the Council. Let's not make things complicated and focus on some high-level distinctions made. First of all, the AI Act mainly targets high-risk AI systems. And there are two types. One type that has a potentially high impact on physical safety and health. You can find them in Annex 1, medical devices, aircraft, toys. The other is systems that have a potentially high impact on fundamental rights. You can find them in Annex 3, for instance, when systems are deployed in the context of recruitment, insurance, or policing. Now, when a system is qualified as a high-risk AI system, there are a series of conditions or requirements that must be met. And it must be met before the AI systems is placed on the market or put into service within the EU. The requirements mainly address the providers, that is, whoever first places the system on the market or puts it into service. And these providers must conduct and document a conformity assessment, after which they can use the CE label, and a violation of the conditions for high-risk AI systems can result in very high fines, up to 30 million euros or 6% of global turnover, or private law liability damages. And we're now still awaiting the update of the Product Liability Directive. More on that will follow when the Commission launches its proposal for that update. Now let's look a bit better at the conditions themselves. Again, high level, the details are all in the Act. First of all, a provider, when they wish to put such a system on the market, they must have a dedicated risk management system in place that estimates and documents that estimation of the deployment for intended purposes. So you decide to build a system to fly planes, then you must have a risk management system that envisages the risks when that system is indeed built for the intended purpose of flying a plane. In the original proposal, your risk estimation also must take into account other reasonably foreseeable purposes. The Council has removed that, and I think that's a grave mistake. If you know that the system that you're putting into the market can be and will probably be used for very different purposes with high risks, then you should consider that in your risk management system. If people want to take risk with their own lives or their own assets, that's fine. But if you're going to take risks with other people's lives or assets or rights, that's not fine. You have to foresee that and mitigate. Another requirement is data governance. This concerns the relevance of the training, validation, and test data, bias monitoring, and they even mention GDPR data minimization, which is strange because it might suggest that only data minimization is applicable. But of course, if in the context of developing an AI system, you are processing personal data, the entirety of the GDPR applies. There is a requirement for, there are requirements for technical documentation and record keeping, including automated logging. There is a whole series of transparency requirements that the provider must make ready for those who are going to deploy their systems. And there is human oversight, both by design and by way of instruction, and I'm returning to that. Briefly on legal protection by design. Legal protection by design must not be confused with legal by design. Legal by design is an oxymoron. It's a contradiction of terms. Why? Because it suggests that you can, by designing a system in a certain way, ensure that using that system is legal. And that is not the case. If you cannot disobey a law, it is not a law, but it's discipline, it's forcing somebody's hand. That's not the law. So we're not talking about legal by design, about forcing people's hands to comply with the law. Legal protection by design is something else. It's basically about integrating checks and balances at the level of the hardware, the software, the architecture, and the interface. And that probably means implementing certain constraints, developing dedicated default settings, hardwiring data minimization, transparency, and we're talking here not just about fundamental rights, but about safety and health, safety controls. A pivotal example of data protection, of legal protection by design is, of course, data protection by default and by design. Article 25 GDPR, which basically says when you begin to develop a system, you have to foresee how people's rights might be infringed and mitigate that. But now look at the AI Act. You could say that the AI Act is a prime example of requiring legal protection by design stipulations. So requiring providers to foresee and build in protection against risks to safety, health, and fundamental rights. And I think we should all agree is that by just writing down that we have a right to privacy and then allowing systems, AI systems that basically take that right away from you or the substance of that right, that this is not going to bring us anywhere. We'll have to make sure that at the level of the architecture, these rights are protected. A quick overview of Article 14, and I'm going to rush you through it because I'm very much curious about your questions. So this is the article about human oversight. And it says that these systems must be designed and developed in such a way that they can effectively be overseen by natural persons when they're used. And the human oversight should aim at preventing or minimizing risks to health, safety, or fundamental rights. Now, how should we do that, human oversight? So the human oversight plays there where a system is deployed. So a government, a web shop exploitation, or an airplane. There where the system is put into use, deployed, that's where human oversight is necessary. And it then says that the provider must identify measures that enable human oversight and build them into the system that they provide. And if that's technically not feasible, must take care that these measures can be implemented by the user. And the user here is not the end user, it's the deployer of the system. So either the human oversight must be built in, means that the system forces the natural person who works with the system to make certain decisions, or it must be implemented at the level of the user, so that's more organizational. Okay, to enable all this, the natural person, as it's called in law, so the individual human person that has been assigned with human oversight must be able to do the following. They must be able to understand the capacities and limitations of the system and to avoid automation bias. Well, that's quite a challenge. They must also be able to correctly interpret the system's output. They must be able to decide not to use, to disregard, override, or reverse the output, and even to interrupt the system. Now, why am I discussing this under legal protection by design? Is because the AI Act basically says these are not niceties. You have to build your system, and I'm not talking about a piece of hardware, but a system that's much broader, that goes towards an architecture, in such a way that at the level of that system itself and all the organizational stuff at the site of the entity that deploys that system makes this kind of human oversight possible. I've already mentioned that the difference between law and ethics, we do not want to depend on the ethical inclinations of whoever develops, provides, or deploys AI systems. Then we have no representation in what these AI systems are going to decide about us. No deliberation, no participation. We're not part, we have no voice. We cannot contest it. In a constitutional democracy, law means democratic participation and the ability to contest in a court of law a decision that's been taken. And that contestation always plays out on two levels. It can be, I didn't do it, what you accuse me of. I didn't kill that person. But it may also be that you are contesting the meaning of the law, saying to the court or to the whoever implemented that law, you're getting the meaning wrong. that it means something else, or saying that law is not valid at all. And these are very important parts of the rule of law. Okay, so I'm last part, innovation towards AI systems that are resilient. So when there are errors, the system is able to deal with that, to cope with that. They're robust. So it's not that one small disturbance or perturbation is going to change the behavior of the system. It should be reliable. That's already a broader term that includes resilience and robustness, but basically means that the functionality that is claimed is actually there and should be responsible. And that brings in what we have just discussed. So AI systems cannot depend on whatever a CEO or a developer thinks is ethical. It is a public interest. We need legal protection, not just niceties, also by way of design. And that means this legal framework is coming up, that there is light at the end of the tunnel that I showed you on the first slide, but that light doesn't just grow like grass. It has to be made. The tunnel has to be made. And that is not just a matter of developers, but also a matter of the law. And I'm going to stop sharing and looking forward to your questions.